Picture this. Dave, a father, 68 years old, sits his two adult children down at the kitchen table. He's got that look, the one where you can tell someone's been rehearsing a conversation in the shower for a week. He clears his throat and says, "So, I want to talk to you about Diane and about some paperwork." The kids feel their stomach drop, not because they dislike Diane, they like her, but they already sense what's coming. This isn't about the wedding, it's about what happens after. That moment, that stomach-dropping moment, is what we're talking about today. Today we're talking about what happens when a parent who's already been through a great divorce decides to remarry and has to figure out how to talk to their adult children about estate planning before the wedding, not after. I've sat across from the table from people who are navigating this, and here's what I've learned. It isn't always a money conversation, although money's certainly involved. I want to touch on 4 key issues here. First, name the fear before you address it. Let's start here, because if you skip this step, nothing else is going to land. Adult children who push back on a parent's remarriage or who get squirrely the second estate planning comes up usually aren't doing it because they're greedy. Well, not always. What they really fear is loss. Losing their connection to a parent, losing that family home with the marks on the doorframe measuring their height over the years, or losing their place in a story whose ending they thought they understood. Consider the case of Mark, whose mother was remarrying at 71. Mark wasn't worried about the wedding. He just kept picturing someone else living in the house where his dad died. That's not about money. It's a form of grief. So if you're a parent listening to this, about to have this conversation with your kids, say the quiet part out loud. Something like, "I know this might feel like I'm choosing someone over you. I'm not. I want to make sure everyone I love is protected, including you." You'd be amazed how much that one sentence can diffuse. Let's look, secondly, at the second death problem. This is where we get into the mechanics, because this is where we can save people a lot of heartache. Here's a mistake I see constantly. A parent remarries, and out of love or honesty, out of not wanting to think about it too hard, they leave everything to the new spouse outright. The thinking is usually something like, "I trust them. They'll take care of my kids when the time comes." Here's the problem. That's not a legal obligation. That's hope. Once assets pass outright to a surviving spouse, that spouse can rewrite their own estate plan the day after the funeral. Maybe they will honor the original intent, but maybe life gets complicated, a health crisis, a new relationship of their own, pressure from their own children. Suddenly priorities shift. I'm not saying every second spouse becomes a villain, most don't, but the legal structure shouldn't depend on everyone behaving perfectly for the next 20 years. I call this the second death problem because functionally, the kid's inheritance doesn't get resolved at their parents' death. It gets resolved whenever the surviving spouse dies, on whatever terms that spouse chooses at that time. So third, let's look at 3 tools that actually can solve this problem. So let's talk some solutions. One solution is what's called a Q-tip trust, qualified terminable interest property trust, which lets a surviving spouse receive income from the trust assets for the rest of their life, so they're genuinely provided for, while the principal is locked in to eventually pass to the children. Nobody gets shut out. Nobody gets full control either. It's a structure built for exactly this situation. Here's how it plays out. Say Robert has 2 kids from his first marriage, and he remarries Linda. He puts $2 million into a Q-tip trust. For the rest of Linda's life, she receives the income that money generates. Say the portfolio throws off $80,000 a year. So she's supported and secure. But she can't touch the $2 million in principal. And she can't decide where it goes when she dies. The moment Linda passes, that $2 million flows to Robert's 2 children, exactly as he intended. Linda was cared for. The kids' inheritance was never in question. But there's a limitation here. The surviving spouse only gets access to the income the trust produces, not the principal itself. For a spouse who may need to dip into the savings, say for a major medical event or a change in living situation, income alone can be restrictive. That's the trade-off for the certainty this structure provides. If you want to soften that edge, you can layer in an AB trust structure, where the estate splits into 2 trusts at the first death. One trust, the marital or A trust, can give the surviving spouse broader access, often including principal for their needs, while the other, the bypass or B trust, locks assets away for the children and stays outside the survivor's control entirely. It's a way to balance taking care of the spouse while protecting the kids' share, rather than forcing an all-or-nothing choice between them. Another solution is an irrevocable life insurance trust, commonly known by the acronym ILIT. An ILIT is a trust that owns a life insurance policy on the insured's life. When the insured dies, the policy pays out to the trust, delivering a chunk of cash to the children outside the probate estate entirely. This is one of my favorite tools because it sidesteps a lot of conflict. The kids receive something concrete and immediate, separate from whatever happens with the house or the investment accounts. Let's look at Robert's situation again. The bulk of his estate, the house, the Q-tip assets, is tied up providing Linda for the rest of her life, which could be another 20 or 30 years. His kids may not see a dime of that until she passes. So Robert sets up an ILIT and funds a $500,000 life insurance policy inside it, with his children as the beneficiaries. When Robert dies, the trust collects the $500,000 and distributes it to his kids right away, tax-free, no probate, and separate from whatever's happening with Linda and the rest of the estate. They don't have to wait, and they don't have to wonder. They get something concrete the moment their father is gone. A third solution is a prenuptial agreement that addresses estate rights, not just divorce. Let's go back to the core problem, protecting the kids' inheritance after the first spouse dies. Robert has passed, and his plan is supposed to take care of Linda for life while eventually passing everything to his children. But there's a threat to that. What happens if Linda remarries? This is where prenups come in, and not the way most people think of them. Most people assume a prenup is only about who gets what if a marriage ends in divorce. But a well-drafted prenup can also have a new spouse give up certain inheritance rights. Here's a clever idea one estate lawyer suggested. Build a clause into Robert's trust that requires Linda to get a prenup before she remarries. Picture Linda, years after Robert has passed, meeting someone new. The clever part isn't really the legal enforceability, it's the social function. The clause gives Linda cover. She can say, "My dear fiancé, I don't want to make you sign a prenup, but Robert's trust requires it, so my hands are tied." It removes the awkwardness of asking. And because Robert's children are named beneficiaries with a legal right to see the trust document, it also gives them standing to raise a conversation with Linda. They can say, "The trust says you need a prenup." Now, in practice, a trust usually cannot force someone to sign a prenup. A valid prenup requires the voluntary consent of both people getting married, Linda and her new partner. A trust cannot compel a third party, like the new spouse, to sign anything. So a strict "you must get a prenup" requirement likely would not be directly enforceable. If your lawyer's instinct is that it might not hold up in court, that instinct is probably right. What is enforceable is putting conditions on the money, not the marriage. Estate planners do this routinely through incentive or conditional provisions. The trust can say that Linda's continued benefits, or the kid's shares, are structured a certain way if she remarries without a prenup. Courts are generally far more willing to enforce conditions on distributions than conditions that restrain marriage itself. Clauses that outright discourage marriage, like "you lose everything if you remarry," are often struck down as against public policy, though conditions tied to remarriage are treated more leniently than conditions on a first marriage. This is state-specific, so it varies, so be sure to check with an attorney in your area. Even if the clause is legally uncertain, it can still serve its practical purpose. The value isn't that a court will enforce "you must get a prenup." The value is that putting it in the trust does two things. It gives the surviving spouse a socially graceful way to insist, and it gives the children a document to point to. The actual asset protection should still be done in the enforceable way, by conditioning distributions. At the beginning of this conversation today, I talked about the kitchen table conversation between Dave, the 68-year-old father, and his adult children about his fiancée Diane, and of course that new paperwork. What would have happened had Dave decided to stay quiet? If Dave had decided to keep the peace? Well, I'll tell you what would have happened. The kids would have found out later. Maybe at the reading of the will, sometimes worse, during a health crisis, when a power of attorney document surfaces that nobody knew existed, naming the new spouse instead of a child who'd held that role for 20 years. And in that moment, it doesn't read as a private decision. It reads as a betrayal, even when it isn't one. Silence doesn't prevent conflict. It just delays it and makes it worse. So if you're a parent in this situation, please have the conversation before the wedding, not after. And if you're an adult child dreading this kind of talk with your own mother or father, know that raising the subject isn't disrespectful. You're allowed to ask questions about your own family's future. Every tool we've talked about today exists because someone somewhere sat down and said, "I love my spouse and I love my kids, and I'm not willing to let a document actually choose between them or accidentally choose between them." That's not distrust. That's foresight. And in my experience, that foresight, that preparation, is the most loving thing you can offer the people you're leaving behind. If you're facing a version of this conversation in your own family, please reach out to me at andrew@wiserdivorcesolutions.com or visit our website, transcendretirement.net. Until next time, take care.
Thanks so much for tuning in to this episode of the Grey Divorce Podcast. To learn more or get in contact with your host, you can visit Andrew's website at transcendretirement.net. Also, please feel free to rate, subscribe, and leave a review wherever you listen to your podcasts. That helps others find the show, and we greatly appreciate it. Thanks again for listening, and we'll catch you in the next episode.
Information provided is educational only and should not be construed as legal or tax advice. Each situation is unique and should be discussed with your tax or legal advisor prior to implementation. Andrew Hatherley is not an attorney and does not provide legal advice. Information provided is financial in nature. Advisory services offered through Hatherley Capital Management, LLC. Divorce financial analysis services offered through Wiser Divorce Solutions, an affiliated company.